let's go into this last thing if we could. A lot of people argue about this. We've touched upon it, but if we could one more time, in the time that we have, the reality of what law we, the Kerns, are under when we go into a court. We talk a lot about common law, civil law, admiralty, maritime, UCC. You want to just kind of segment that out so it's clear to folks?
Well, the bottom line is it's contract law. It's under maritime in an admiralty court. They merged admiralty, equity, got rid of common law, and I have some court cases that I just found that defines the fact that we don't have no more common law. I don't have them. They're so new to me that I can't even give you the site, and I've got to read them some more to digest it. You know, I read a case 5 times, and I read the case backwards. Many people don't understand. Read the case backwards.
I do, because what happens is you start to drift. Your eyes go across the words after so many times, right?
Yeah, but what you want to do is you want to see what the court's determination was in the very beginning. Was the guy guilty? Was the guy not guilty? And why?
Okay.
In the conclusion, all right? Now you go and you start reading from the front down, and now you know the guy lost, all right? Why did he lose? If you're reading it down from the top down, and by the time you get to the bottom, you forgot what you read, especially in a long case, and you read what the conclusion is, and now, why did he lose? You know? Because you've got this presumption in your mind when you're reading the case. All right, you're looking for something. You can't look for anything. You've got to read the conclusion first and the decision, then go back, and then you start reading, and then you'll hit on certain key words that was in the conclusion. You say, aha, I can now see why he lost, or I can see why he won. But equity, okay, they're all there for the court to use how it wants to use it.
Okay.
Now let's take contract law. I go down to buy a thing from Sears, and I take it back because it don't work, and there's a dispute, so we go in. Now, what court are we in? Okay, we're in the basic admiralty court, but we're going to go by contract. And now we're going by contract law. That's why Repi on contracts and others are so well published.
But is contract does it only exist under admiralty?
Most of the time, yes. There are some cases where it's not.
Okay.
Now, contract of insurance, that's admiralty. Straight out, boom, admiralty.
Okay.
Contract of motor vehicles, straight out admiralty. You'll find it in Benedict on admiralty, in the 7th edition. That's the best one that I like to use. I've got the original one, but people can't get that. But anything after the 7th edition, they get so convoluted and everything that you get lost.
Okay.
All right. But so I have a dispute with my hurricane went through and blew my roof off. So I go to the insurance company and say, well, I want to give you half of it. Well, wait a minute. No, this is a dispute. Now it's a contract dispute. But it's in admiralty because it's a maritime claim.
What makes it a maritime claim?
Insurance.
Okay.
DeLovo versus Boyd. Way back, and U.S. Steamship versus New Jersey Steamship Navigation. Yeah, but
this isn't happening over water, so how come, if it's terrestrial, it's maritime?
It don't matter, because what they did in 1857 is they moved admiralty inland no matter what.
Okay, now is admiralty and maritime synonymous?
No, there is a little difference. And when I read the difference on that maritime, the only way I found it was in on the Benedict on admiralty in the 1850 edition, which is the very first edition that I got, that most all judges in the know have this bench book in their chambers. They don't go outside their chambers. Now, let me see. It says maritime does not depend on a particular court. Civil law is admiralty, not common law. This is right out of the American Admiralty as Jurisdiction and Practice.
It's civil, not common law.
Yes, it says in Section 5 on page 3 about the Admiralty law is indebted for many of its characteristics to the circumstances of the countries in which it was at first administered. It says, in England, where the common law was the law of the land, the civil law was held to be the law of the Admiralty, and of course of proceedings in Admiralty closely resembled the civil law practice. So therefore, when you talk about civil rights, you're talking about Admiralty rights.
Okay.
There's 5 ways of Admiralty. And the Constitution of the United States grants to the federal government judicial power over all cases of admiralty and maritime jurisdiction. This is the whole of the grant of that branch of judicial power, and brief and simple as it is, upon the true construction depends the whole of the American admiralty jurisdiction. It has received 5 different constructions, and then they list all 5.
Can you give us headings? What the 5 are?
Well, let me see. That this Constitution grants only those few cases in which the English High Court of Admiralty was permitted to take cognizance of time of the American Revolution. The actual jurisdiction of the state courts of Admiralty, which were in existence in the adoption of the Constitution of the United States, was alone embraced in the grant. The words Admiralty and Maritime relate simply to subject matter, and where used in that general sense were employed, embraces all the cases relating to ships and shipping, which under the maritime municipal regulations of each nation, which arise under the general maritime law. In endeavoring to ascertain which of these constructions ought to prevail, I shall first in the place recur to some general principles, and then they go on to the general principles. And this book is about 800 and some odd pages thick, and it's the original admiralty practice in jurisdiction and forms in the United States in 1850.
Could you give us, in a sentence or so, what the distinction is between maritime and admiralty? I mean,
okay, I was just looking in here to give you the right maritime, not depend on a particular court. They must use the English dictionary in all the laws in this country. This is 1850 now. Oh yeah, it's what it says. It says, still is not to be forgotten that our people were not homogeneous, but consisted of persons from all civilized nations, English, Scottish, Irish, Welsh, Dutch, Swedes, and French. By some conquest, and some by immigration, were mixed and united to make the American nation. Got that?
Mm-hmm.
Say United States, the American nation.
Mm-hmm.
All right? And that's where it then says, it is to the English law and to the English dictionaries that we must resort for the meaning of those terms.
All right.
But it by no means follows that we must look to the same source of the structure and jurisdiction for our national courts or for the rules of decision which they are to follow. The force of the common language even added to that of our historical connection was altogether too feeble properly to give our new-made and original political institutions any transatlantic odor, much less to characterize them by strong English analogies. Maritime, I'm trying to find here. The 5 ways of admiralty is administered. Transactions embraced in maritime congress may only be classified in a simple and intelligible order. Vessels, the only means by which navigation, management of the vessel is entrusted to the leader. Also, whether people know it or not, a car is a vessel, comes under international law.
Okay.
The common law, I'm trying to find. I have as many pages in here porcupined as I do pages.
Which means there's no sense to it.
Yeah, I'm trying to find all attorneys' conflict of interest, process of rem, who we are in admiralty, real party of interest. Now, in the warring thing, both parties are the actors. Libel is some called the promovent, actor, and plaintiff. Now, actor is a person. That's his character that he operates in.
Mm-hmm.
All process in admiralty, all IRS process in admiralty is liens and stuff, they're all admiralty.
Okay.
Admiralty applied to statute. Darn. Rule 44, admiralty. Rule 53. Rule in the Federal Rules of Civil Procedure, Rules 636 and 28 is all admiralty rules. Rule 55 to 58 is admiralty. And people don't understand that, but that is admiralty. There was a difference in here. Darn it, I wish I could find
Well, I tell you what, you can email it to me because obviously...
Yeah. I'll email that to you.
And then by the time the show airs, I cannot put that in the somewhere in the show. That answer. So I mean, the good thing about doing a recording is the fact that I can amend it.
Okay, what is maritime? Maritime law regulates and enforces all maritime contracts. It does not take cognizance of agreements not in the